Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we have picked up a couple of important articles from the Hindu which are very significant from your UPSC and KPSC examination point of view. Let's get started and look into the first article. The first article is about Bigg Boss. No, we're not going to speak about the entertainment, we're not going to speak about the rumors, but all that we will try and focus is with respect to the Wildlife Protection Act of 1972. This article is important from your GS paper 3, which happens to be environment and ecology. What is this issue all about? Let's look into the context. Bigg Boss KAS season 10 contestant Vartu Santosh was arrested by the forest department for allegedly wearing a tiger claw and has been sent to 14-day judicial custody. What is this article speaking about? We have one of the prominent shows in Canada which happens to be Bigg Boss. Bigg Boss is also present in other channels and other languages as well, which is not the subject matter of discussion. The point is that this person was wearing a tiger claw in the chain and it was around his neck, and as a result he did express his view on it that he is wearing the tiger claw, and as a result the forest officials have come to the Bigg Boss house and have taken this person to the judicial custody. Prima facie they have said it may look like a tiger claw. Further investigation will be conducted, and if it is proved, penal actions will be enforced on this person. Now the question is, why was this person arrested? The person was primarily arrested because tiger happens to be one of the species which is present under Schedule 1 of the Wildlife Protection Act. We have a couple of schedules in the Wildlife Protection Act. When you look into the original act, the original law had 6 schedules which include Schedule 1 for animals with highest priority, particularly endangered species, Schedule 2 species with a relatively less degree of protection, Schedule 3 and 4 for non-endangered species, Schedule 5 for the vermin and Schedule 6 for the plant species. This Wildlife Protection Act was recently amended. According to the amended provisions, what we have is only 4 schedules. So remember, in case there is a question which is being asked in UPSC or in KPSC or any other examinations, how many schedules are present in the Wildlife Protection Act? Presently what we have is 4 schedules. Earlier it was 6, currently what we have is 4 schedules. Which are these 4 schedules? Schedule 1 containing animal species enjoying the highest level of protection, Schedule 2 for animal species subject to a lesser degree of protection, Schedule 3 for protected plant species, Schedule 4 for scheduled specimens under the CITES. This happens to be an international convention. So according to the present laws, we have tiger, elephant and many other species which are protected and has highest level of protection. Where is tiger present? Tiger is present under the Schedule 1 containing animal species enjoying the highest level of protection. So basically we have the Wildlife Protection Act. The Wildlife Protection Act came into picture in the year 1972. Basically it wanted to protect the animal species, it wanted to protect their habitat and also prevent illegal trading as well. So in order to prevent illegal trading, protect the animal species and also their habitat, the Wildlife Protection Act of 1972 came into the picture. Now, once the Wildlife Protection Act comes into the picture, what does it say? It says that in case people possess, let's say, animal skin, for example, people would want to have animal skin like the tiger skin, so on and so forth. So up until 1972, if people had these possessions, in case they want to continue with it, they require the permission from the government. So they require the license, and this license has to be this license has to be given permission. So it has to be renewed every now and then. So in case they have this particular ancestral skin, or let's say the tiger claws, teeth or the nail or anything like that, or with respect to any other species as well, they will require the permission from the government. So the government will have to give the license to them, and this particular license has to be renewed, and this license will have that this so and so person will have the skin of the tiger, the claws of the tiger, the teeth of the tiger, so on and so forth. This was up until 1972. But after 1972, we have the Wildlife Protection Act. So in case a person has something like this, he has to take the permission of the government. So So if the permission of the government, that is the state and the central government's permission is not taken, retaining any such teeth or the claws or for example the hair and skin will become illegal under the Wildlife Protection Act. So if we look into the Wildlife Protection Act, we have a word under the definition called as trophies. What does trophy include? Trophy means the whole or any part of any captive animal or wild animal, which includes whole or any part of the captive or the wild animal. So which means any part also includes tiger claws as well, other than the vermin, which has been kept or preserved by any means, whether artificial or natural, and includes rugs, skins, specimens of such animal mounted in whole or in part through a process of taxidermy, antler, bone, carapace, shell, horn, rhinoceros horn, hair, feather, nail, tooth, tusk, musk, eggs, nest, as well as honeycomb. So in the present situation, since the Bigg Boss contestant had accepted that he has the nail and the nail of the tiger, which is why he was arrested. And also note, even if it happens to be taken from the dead species, that is not allowed under the present law. For example, let's say a tiger has had a natural death. It has passed away naturally. None of them have poached into it. None of them have killed it. There is no hunting whatsoever. Even if it is taken out of a dead tiger, even in that case, it requires the permission from the government. If no permission is taken, it is still an illegal offense. Generally, people have these nails or the tooth or the skin because of their belief and also because of certain superstitions as well. Let's say for example, if you have a tiger claw, that will create and generate more positive energy for you. It will release and take away all the negative energy. It will bring in a sense of courage as well. It will improve the willpower over a period of time, and this will have an ornamental display that I've done something courageous, great in my life. This will also improve the willpower over a period of time. And in few countries like China, they also allege that they also have medicinal values as well. So the primary idea or why people have these tiger claws, so on and so forth, is the belief that this will ward off the negative energy, evil energy, and will take away, and all the black magic and so on and so forth that is performed will not affect them. That is why they wear it as an ornamental display. But if it is done so, it is barred under law, and as a result they can be imposed with penal provisions. Where do we have the penal provisions? The Wildlife Protection Act of 1972 and the subsequent amendments gives penalty under section 51 of the Wildlife Protection Act. Any person who contravenes any provision of this act or any rule or order made under, who commits a breach of any of the conditions of any license or permit granted under this act, shall be guilty of an offence against this act and shall on conviction be punishable with an imprisonment for a term which may extend to 3 years. So if it is found out that he is actually killed or he has got it through an illegal means, then it may extend up until 3 years, or it may also go with fine as well. The court may also impose fine as well, which may extend to 25,000 or with both. And subsequently, if they are caught for the second time, then the punishment will not be less than 3 years but may extend to 7 years, also with fine, which shall not be less than 10,000 rupees. So this will be the penalty if a person holds tiger claws whatsoever. So the point is that holding tiger claws or the skin or any other trophy is barred under the Wildlife Protection Act, and if it happens to be a Schedule 1 animal, the penalty would be far more rigorous as well. So remember, even if it is dead, even if you have got it from the ancestors, you have to get the license from the government. Without the license, if you continue to hold, that is still considered illegal according to the Wildlife Protection Act. It is this that we have to understand with respect to this article. Now let's look into the next article. This article here is speaking about one of the primary laws passed by the government, which happens to be the Criminal Procedure Identification Act. Let us try and understand what is this Criminal Procedure Identification Act. Let's say for example, there is a criminal. This criminal has committed an illegal offense. So it can be an habitual offender, or it can be a person who's committed the crime for the very first time. what if this prisoner has committed an offense and he feels that he should not be giving any of the samples, let's say for example fingerprint, or for example the iris scan, or for example the palm expression, so on and so forth. So the prisoner is, let's say, arrested by the police officers. They have to conduct an investigation. In that particular case, they go on to say that we will not be giving fingerprint or the iris scan. Why? Because this is against self-incrimination under Article 20 of 3. So at this particular moment, what we required was a law. That law originally, or this particular law was passed in the year 2022, but originally what we had was the Prisoners Act of 1920. So what is this Criminal Procedure Identification Act? The Criminal Procedure Identification Act replaced the Prisoners Act of 1920. So originally when you had the prisoners, these prisoners iris scan would be required, fingerprint would be required, and such will be saved in the database, so that in case they commit any other offenses in the near future, we would be able to look into this particular database, match it with the existing ones, and ultimately say so and so person has committed this particular offense. So this is helpful for the investigation. This will be helpful for the police officers to understand who has conducted this particular activity and ultimately bring this person under the law books. So what was the original intent of the Prisoners Act of 1920? The original intent was that you will have the prisoners who will be arrested. Once they are arrested, you have to take the fingerprint, you have to take the iris scan, you have to take the palm expression, so on and so forth. So how do we do it? We require the backing of the law. Why backing of the law? That is because these prisoners would deny giving their fingerprint or the iris scan. Primarily they felt that it was against the Article 20 of 3, which is against self-incrimination. So in order to make sure that they are able to provide these kind of fingerprint, iris scan, so on and so forth, what we had was the Prisoners Act of 1920. So to replace the Prisoners Act of 1920, what we have is the Criminal Procedure Identification Act. So once you look into this particular act, what was originally envisaged under the Prisoners Act of 1920, the statement of objectives and reasons for identification of the Prisoners Act states that the value of scientific use of finger impressions and photographs as agents in the detection of crime and identification of criminals is well known. It further goes on to say that although lack of legal sanction has not created problems before, there were increasing cases of prisoners refusing to allow take their fingerprints or photographs to be recorded. Therefore, to prevent such refusal in the near future, and also place the taking of measurements, etc., which is normal incidents of police work in India as elsewhere on regular footing, it was considered necessary to enact the Identification of the Prisoners Act. We did discuss about it, that they were denying it. In order to ensure that they did not deny, and we also have a central repository and a database, a law was required so that we save all the data in one single repository as well as in the state as well, which is why this particular law was created. Why was this law currently being replaced with a new law? That is because we have had recommendations flow over a period of time, which has said that when the Prisoners Act of 1920 was formed and subsequently we have had it, they did not have the modern technology to include palm expression. Let's say for example, we have the fingerprint technology where we would be able to take the fingerprints of the prisoners. We would also be able to take the iris scan as well. But the iris scan and the fingerprint will also require other additional subject matters as well. Let's say for example, the palm impression. This was not taken under the Prisoners Act. So the Prisoners Act was developed and designated and was brought into picture before the 2000s, where technology was not all that great. But now we have technology which has improved over a period of time. And in 1980, the 87th report of the Law Commission of India undertook a review of this legislation, recommended several amendments. This was done in the backdrop of the state of UP versus Ram Babu Mishra case, where the Supreme Court had highlighted the need for amending the law. We did have the Prisoners Act of 1920, but changes had to be brought into picture. For example, the government is bringing a large-scale changes when it comes to the criminal structure. We did recently discuss about the same as well. We did discuss about the criminal amendment bills as well. IPC being replaced by Bharatiya Nyaya Samhita, CRPC being replaced, evidence being replaced. So these are the changes that the government is bringing. An aspect to it is also this Criminal Identification Act. So the first set of recommendations laid out the need to amend the Act Act to expand the scope of measurements to include palm impressions, specimen of the signature of the writing and specimen of the voice. The second recommendations raise the need for allowing measurements to be taken proceedings other than those under the code of the criminal procedure. In fact, the Law Commission report also notes the need for an amendment is reflected by the numerous amendments made to the Act by several states. So several states were also bringing changes in the Prisoners Act of 1920 as well. So in order to accommodate and bring changes, what we required was a new law. So constantly bringing changes was not good for the law. So what they thought was that we will go ahead and bring a new law, and that new law which replaced the Prisoners Act of 1920 happened to be the Criminal Identification Act. So what are the major differences between both these laws? A comparison between the Identification Act. One happens to be the Prisoners Act, the other happens to be the Criminal Procedure Identification Act. Persons whose measurements can be taken. So such a person should be convicted of an offence punishable with rigorous imprisonment of 1 year or upwards. So only a person who has imprisonment that is enforced by the court of law, which is 1 year or more, only such person's data will be kept up and kept in the repository. So if there is a person who is convicted for less than 1 year, such person's data will not be stored in the repository. But when it comes to the Criminal Procedure Identification Act, that is the new law, if convicted of an offence punishable under any law, so it means that 1 year which is present under the Prisoners Act of 1920 is completely deleted. So if a person is convicted, let's say for example even for 10 days or even for 1 month or even for 6 months or even for less than 1 year, this person's imprint, the palm impressions, the iris scan, fingerprint will be taken and stored in the repository. So the major difference is that in the Prisoners Act only 1 year and above this data was saved, but when it comes to the new law, even if it is less than 1 year, even if it is 1 day that is convicted and is present behind bars, such person's data will be stored and ultimately stored in the repository. Should be arrested for an offence punishable with rigorous imprisonment of 1 year or upward if arrested for an offence under any law or detained even under the preventive detention law. So under the new laws, even if he is detained under the preventive detention laws, that person can also, samples can be taken up. What are these preventive detention laws? There are two types of punishments. One is preventive punishment. There are two types of convictions. Conviction as in, let's say for example, if a person is convicted, which means his evidence is proved, the court is able to prove that it is prima facie this person who's committed this particular offence, he will be convicted. So once he is convicted, he will be thrown behind bars. So punishment will be given to him. But in the second case of preventive detention, a person has not been convicted. There is an apprehension that this person may commit an illegal activity. In such a case, preventive detention basically leads to that particular aspect that a person is detained and he is yet not convicted. So there is an apprehension he may conduct an illegal activity. To prevent that illegal activity, preventive detention laws are present. For example, we have the preventive detention laws which can be brought up by the state governments for the public order. You also have the central government which can take a preventive detention laws, for example, for the sovereignty of the country. So we have the National Security Act which is present in the state of Jammu and Kashmir. So these are the preventive detention laws which are not present under the Prisoners Act but are present under the Criminal Procedure Identification Act. Measurements that can be taken in the Prisoners Act, we had finger impressions, foot impressions, measurements and photographs, but this scope has been enlarged under the Criminal Procedure Identification Act, which includes finger impressions, palm print impressions, footprint impressions, photograph, iris and retina scan, physical biological samples and their analysis, behavioral attributes including signatures, handwriting or any other examination. Then we have destruction of the measurements in case of acquittal, discharge or release if not previously convicted of any punishable offence with rigorous imprisonment of 1 year or more. The data will be deleted under the Prisoners Act. So a person's data will be collected. If he is acquitted, it will be immediately deleted. But in case, with respect to Criminal Procedure Identification Code, in case of acquittal, discharge or release if not previously convicted of an offence, punishment with rigorous imprisonment for any term. For convicts, records are to be destroyed only after 75 years of collection. These are the major differences. This is where we have to know some of the concerns that are associated with the Criminal Procedure Identification Act. One of the major concerns is Prisoners Act of 1920 provided for the measurements which will be taken for those convicted or arrested of offences that entail imprisonment for 1 year or upwards, but the current law allows for measurements to be taken even if a person has been convicted for any offence, including the petty offences. So even if it is a petty offence, even if it is for a day or two, this person's data will be stored in the repository, which is against the violation of the previous laws. To give you an illustration, person W is found guilty of rash and negligent driving. He may be having his signature collected and stored in a central database for 75 years. The law permits this. Why keep his data for 75 years is another point of view. Then there is another argument which is vague as well, but for the sake of argument we have to take it, that this law violates the right against self-incrimination enshrined in Article 20 of 3 of the Constitution. However, this has been overruled by the Supreme Court in the state of Bombay versus Katti Kallu Ogad. The Supreme Court had conclusively held that non-communicative evidence, that is evidence which does not convey information within the personal knowledge of the accused, cannot be understood to be leading to self-incrimination. In fact, when you look at CRPC section 53 and 53A, it already has provisions with respect to rape, so on and so forth. What if a person's semen samples have to be collected? Is it against self-incrimination? No. This means that there are few samples which have to be collected, and this is not self-incrimination. Voice samples, if it has to be collected, or let's say for example, if DNA samples have to be collected, this is not self-incrimination, says the Supreme Court of India. And to regulate all this, what we have is one of the bodies. Where will this repository be saved? This repository will be saved in what is called as the National Crime Records Bureau. This happens to be an institution which happens to be a central organization tasked with rolling out the act, was assigned the task of finalizing the standard operating procedure. So we have the National Crime Records Bureau, which will have the repository, which will have the data for this entire database, and they will also come up with the standard operating procedure as to how this particular procedure has to operate. And at the same time, you will also have the states which will also have their own repository, and in case they require any assistance from the NCRB or with any other investigating agencies, the state governments would be able to coordinate with them as well. How is this law present in many other countries? It is not just with India, it is also present in other countries as well. For example, in United States of America, we have the US federal and state laws differ to some degree on biometrics, but the collection of information beyond photographs and fingerprints is also catching on. US federal law has acquired collection of DNA samples from convicts since 2004 and from individuals who are arrested facing charges or convicted since January 2009. A suspect's failure to cooperate in such a collection is independently a federal crime. Similarly, in the UK, photographs of the face, fingerprints, DNA from a mouth swab or head hair root are collected on arrest. However, to collect blood and urine samples or dental impressions, UK police need permission from the suspect as well as from a senior police officer. This is the existing structure in couple of other countries as well. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says an India-Canada bonding that is in danger of snapping. We have discussed about this article in our previous daily current affairs discussion. So in just, if I have to say, what is this India-Canada relationship all about? Why is it in concern? That is because we had one of the persons who was killed in Canada. The allegation that is made by Canada is that he happens to be a Canadian citizen, but he was killed by the agencies of India. Generally, even if such things happen, according to the well-established diplomatic channels, if you feel that there is an apprehension that an agency of government of India has killed or assassinated a certain individual, then in that case, behind the channels, because we have good diplomatic relationship between India and Canada, and as a result, even if such a thing may have existed or may have happened, Canada should have spoken in a right way through the right channels. They should have spoken to the government agencies, they should have spoken to the Ministry of External Affairs in an indirect way. But what happened in the present situation? You have the Prime Minister of Canada, Justin Trudeau, who comes over and speaks in the Parliament and makes an allegation without having any evidence whatsoever. Why does he do so? That is because he has a significant population who vote for his political party, who happen to represent a particular community in Canada who come from India, and as a result, in order to convince them, in order to appease them, in order to win their electoral votes, he happened to speak in the parliament that he said that agencies of India happened to kill the citizen of Canada. This was not the right way to do. Ideally, this should have been done in the black channel diplomacy, but since he did not do it, there was diplomatic clash between India and Canada, and as a result, Canadian embassy people were asked to leave India, and in Canada, Indian diplomats were asked to leave Canada, and the relationship is not that great. And as a result, the author in this particular case says that it is the migrants who have moved from India to Canada who are the major sufferers. This is what the author speaks about in this article. Once you look into the data, what exactly happens? You have a lot of data which covers that when you look into the population of India and Canada, there are a large number of people who have been staying in Canada. For example, according to the census of Canada 2021, the country is home to 1.86 million people of Indian origin, about 5% of the country's 36.99 million population, and 5.8% of 32 million strong global Indian diaspora. According to Immigration, Refugees and Citizenship Canada data, 2,25,940 or over 40% of 5,49,260 total study permits to international students were issued to Indians in the year 2022. Since there are a lot of Indians who are traveling to Canada, this ultimately may lead to some concerns for these individuals. That is where the author brings into picture one of the law called as the Global Compact for Safe, Orderly and Regular Migration Agreement. So this is also called as GCM. What is this law all about? The Global Compact for Safe, Orderly and Regular Migration Agreement, or the GCM, is basically about the human rights about the people who migrate from one country to another. Let's say for example, I am in India. I migrate to United States of America, or let's say for example, I migrate to Canada, or for example, Australia. Since I go to this country, I have certain rights which are given to me. For example, let's say I should not be discriminated. There should be no xenophobia against me. What is xenophobia? Xenophobia is against people of a certain country or against a certain race. So if I am traveling to United States of America or I travel to Canada, there are few human rights or basic rights that are given to me. Such rights should be given to all people when they travel from one country to another. Canada is signatory to this agreement, and Global Compact for Safe, Orderly, Regular Migration Agreement, where India is also signatory to it. So this basically identifies that there are some basic human rights, that there are basic rights which have to be granted to all citizens when they move from one country to another as migrants, and at the same time there should be no discrimination whatsoever. What are the rights that are covered? When you look at the laws, strengthening evidence-based and human rights policy making and public discourse on migration, minimizing the adverse drivers of migration including combating poverty, discrimination, addressing climate and disaster-related displacement, ensuring migrants' rights to information and to a legal identity. So in case I go there as Ajay, I should be recognized as Ajay, and I should be the person who will be provided all the legal identities. For example, I should be able to have children, I should be able to transfer the properties that I own to my children, so on and so forth. This is the legal identity, individual identity that I have as a person. So expanding and diversifying availability of pathways for the safe, orderly and regular migration, taking into account the particular needs of migrants in situation of vulnerability, protecting the right to decent work and other labor rights for migrants, addressing and reducing vulnerabilities and human rights violations in the context of migration. So the minute I go to another country, all the discrimination that is present should be completely eliminated, and all the basic services like health, education, social support should be provided by that government to the people who move from one country to another. So the author says that when you look into safe, orderly and regulatory migration, which are the countries which are responsible for it? One is the country where people have moved from one country, that is from the source. So India happens to be the source country which has to take care of its diaspora, and which is the destination country. The destination country happens to be Canada. So for a sustainable living, for the sustainable healthy living, both these countries will have to come together and should ensure the protection of the migrants. So in the present situation, since the there's the origin and the destination country. They do send remittances and investments back to India, transfer of knowledge and migration for developmental engagement for the two countries and their migrants and their family and the diaspora members. It is important that both these countries come together and ultimately take care of the concerns of the migrants. But in the present situation, that is not taken into picture, says the author. So basically, the migrant rights had to be taken into picture. Their rights have to be safeguarded as well. So more measures, more policy schemes will have to be generated by the Canadian government, says this article. So this article currently goes on to say, if you look into the data, then we have had more of imports and exports between most of the countries. So this is the data that is being given by the author. Recently, we've also had on May 1, 2014, a stamp commemorating the 100th anniversary of the arrival of SS Komogoto Maru, which was released by the Canada Post. On May 18, 2016, the Prime Minister of Canada, Justin Trudeau, delivered a formal statement of apology in the House of the Commons for the Komgata Maru incident as well. But then, in the present situation, diplomatic tensions between two governments seem to be undermining the Objective 19 of Global Compact for safe, orderly and regular migration. So measures will have to be taken, is what is this article all about. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says mitigating tragedies in the Himalayan region. We did discuss about this article in greater detail in the last couple of daily current affairs discussion. However, what we have to understand right now is there are some statements which are made, that is from the statistics point of view, which is a study published in Nature this year indicates that 90 million people across 30 countries live in 1089 basins containing glacial lakes, or 1/6 live within 50 km of glacial lake and 1 km of GLF runout channels. So we saw it in Sikkim that there was the glacial overflow which resulted in the floods, and as a result property was lost, economic activities were lost, lives were lost as well. And we've also seen landslides and flash floods in Himachal Pradesh and Uttarakhand. So this is reoccurring every now and then in the Himalayan states. So what are the existing measures that the government have taken? We've already discussed this, but we will only stick with this article, what it says. So NRCC's Atlas have provided high resolution data via remote sensing, which allows for monitoring spatial change. Central Water Commission is conducting hydrodynamic assessment of high risk lakes, mapping water flow, height and routing simulations using digital elevation models. The NDMA's national guidelines provide states with a technical overview of the hazard and risk zonation and suggest strategies for monitoring, risk reduction and mitigation. These are the measures that have already been taken. Apart from that, what measures have to be taken? So this article says that we have to take a couple of other measures as well, that there is multitude of glacial and temporal variations in global recession makes monitoring and estimation of the risk more difficult. So what we have to do is come up with more monitoring, mitigation and early warning strategies. So come up with scientific rationale, scientific equipments, put these scientific equipments in those places, monitor it constantly. So even before there is a breach, we have to ensure that it does not breach, and even if there is a breach, there has to be mitigating strategies as well. Many geotechnical solutions for mitigation have been tried globally. For example, excavating channels for regulated discharge. So if there is a lake in this particular case, so if this happens to be the natural flow, we have to create alternative flow to this particular channel, so that it is not one single channel that we have an alternative channel whereby the amount of destruction that this causes will also be reduced. Drainage using pipes and pumps. For example, the water has to be sucked out and taken out from this particular lake every now and then, because we constantly have a monitoring. So we know for the fact that if this particular lake has more water, it will breach and ultimately cause significant damage. So we have to take the water out, drainage of the water, use pipes and ultimately put a motor and take the water out, spillway construction and setting up small catchment dams. So in case there is breach, there has to be a dam that is constructed, and this dam should safeguard the regions below this particular region. So such measures have already been taken. We have to ensure that more such measures will be taken up in the near future. And the most significant risk of such disaster is downstream hill communities and authorities who get a very short time to respond. They stand to suffer serious damage to life, property and livelihood. Such events bring permanent changes in morphology. So what we require is a multi-stakeholder approach where you have the government, the private agencies and the hill communities all come together. They should be able to know that in case there is a breach, how can they safeguard themselves? That has to be thought as a part of awareness. So these are the measures that have to be taken into picture, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says food labels to have QR code to help the visually disabled. The article here is speaking about the measures that have to be taken for the physically disabled. For example, if there is a biscuit packet, or let's say for example, if there is any of the food items that you would buy in the market, let's say a cake packet or a biscuit packet or salt, so on and so forth. What will it have? It will have the ingredients. It will also have when it was manufactured, when is the expiry date, what are the ingredients, how much of salt, sugar and all that is present. So all this is present on the packet, but this will not help the physically disabled. For example, let's say a person is visually challenged, he would not be able to see, or let's say for example a person is not able to hear, he would not be able to understand what it is. So in such cases, if a person is not able to see what is the ingredients as well as the manufacturing date as well as the expiry date, this will require an alternative, and that is what the FSSAI has come up with. So it has said that in all the future packets, for let's say for example a biscuit packet or whatsoever, what we will have is a QR code. The minute a visually impaired person is able to see and scan this QR code, this QR code will give out the information to him saying that so and so ingredients are present, this was manufactured on so and so date, the expiry of this particular product will be on so and so date, it has to be used within so many days or so many months. So all this will be prescribed once a person scans this QR code. Why was this brought into picture? Because the Rights of the Persons with Disabilities Act of 2016 recognizes the rights and needs of individuals with disabilities, which emphasize accessibility and the promotion of health for the persons with disability. In order to help the disabled, in order to help people who have been suffering from visual disability, to give out the information to them, this particular alternative has been done. So apart from the QR code, whatever has been the regular practice of including the ingredients, manufacturing, expiry will always be present. In addition to the existing mechanism, they will add the QR code. So the person who is visually impaired is not able to see anything. If he scans this QR code using his mobile, it will read out the information. So that person will be able to decide if it is safe or not. That is what this article is all important from your GS paper to governance perspective. Now let's look into the next article. This article is important from your geography, world geography, and it is very important from your preliminary examination point of view. This article here makes a reference to the Death Valley National Park. So where is Death Valley National Park? The Death Valley National Park is in the state of California in the United States of America. So we have Death Valley National Park where in California, where in United States of America. Such questions can also be asked in your preliminary examination. There are few important facts about the Death Valley National Park, some important species which are present in this Death Valley National Park. Which are these is what you have to put on the comment section. So this is it for today. Thank you for watching. All the best.